Good afternoon, everyone. I apologize. I'm so sorry. We had some network challenges, but it has been resolved now. Okay, so quickly, this webinar brought to you by Shola and Afana. My name is Diana Igudekro, and I'll be moderating this webinar. Now, before we start, I would like to set some ground rules. If you have questions in the course of this webinar, I would like for you to send your questions to our chat box. And then if you are still not able to send questions to the chat box, you may send your questions to our email. Our email is info@shololafana.com. So a brief background before we delve into the issues we'll be discussing today. Now we're going to be talking about some issues in the Freedom of Information Act. Now the Freedom of Information Act was enacted in response to the secrecy associated with government policy development and decision-making process. So now, despite the Freedom of Information Act, we have discovered that there's still some challenge, in accessing public information that should be available to the public or should be disclosed to the public. And probably I feel like it's because of the illiteracy. People do not know about the existence of the Freedom of Information Act and probably some rigid legal procedures. So in the course of our webinar, we'll be discussing the rights under the Freedom of Information Act, the obligations that institutions have under the Act, and then the public interest test. So I will be introducing our panelists, Jemima and Allen. Jemima Bestman. Jemima is the lead of our FOI practice group in Shola and Afana. She is a seasoned and resourceful professional who has authored several articles on competition law and freedom of information law. Hi, Jemima.
Hi, Diana. Thank you for that wonderful introduction. I'm glad to be here, and I hope we have a fruitful session today. Apologies for the whole network shenanigans. Thank you.
Thank you. Alan is the lead of our data protection practice group. He's a seasoned data protection practitioner. For data controller, professors, several articles on telecommunications and live stream. Hi, Alan.
Yeah, hi, Diana. Good afternoon. Nice seeing you again. Hi, everyone. Good afternoon. Thank you for having me, and it's a pleasure being here. Thank you.
You're welcome. Okay, so quickly, without wasting much of our time, Jemima, please. What is freedom of information? I mean, we learn about Freedom of Information Act, Freedom of Information Act. So what is freedom of information?
So freedom of information is basically the rights we have as individuals, as citizens, to have access to information or records in the custody of public institutions. Now, we know that public institutions exist to serve the interests of the citizens. Now, freedom of information is a tool we have to hold these public institutions accountable for their actions. So basically, that is what freedom of information is.
Thank you, Jemima. So yes, you said that we have the right to access information. So what kind of information are we looking at here?
We can ask for a wide range of information, regardless of how it is stored. Okay, we can ask for a wide range of information, regardless of how this information is stored. We can ask for emails, video recordings, audio recordings, pictures, hard copy documents, like minutes of meetings, charts, graphs, maps, what have you. We can ask for a wide range of information.
Yes, so thank you, Jemima. You mentioned that we have the right to apply for this information, to request for this information. Can a non-citizen exercise this right? Can I exercise this right? Is there like a restriction? Also, must I state must I state the reason for requesting the information? And then I feel like there should be a cost implication. There should be a cost implication. There should be a cost attached to requesting this information. Is there something like that?
Most interesting Freedom of Information Act to me is the fact that anybody can make an FOI request, regardless of age, race, class. The Act does not specify a certain category of persons that can make an FOI request. You can make an FOI request even anonymously. You don't have to state your reason for the request. You can just go ahead and make your FOI request. Now, another interesting factor, I know that we're all trying to find ways to save money, but another interesting factor, the fact that there are little or no cost implications. This basically the only thing you'll be spending, the only cost is the cost for acquiring that information. Let's say photocopying the document or applying for a certified true copy of that document. So that is the only cost you've been incurring to get an information. So there's no extra charge when you want to make an FOI request.
Wow, thank you. Thank you so much, Jemima. So yes, you've mentioned that we have the right to access information from institutions, entities, and all of that. So what entities are we looking at? Public, private, government? Please just enlighten us.
Okay. So the Act calls these entities public institutions. It describes them as public institutions, and it categorizes them into three places. The first is judicial, executive, legislative bodies, agencies, committees, subcommittees, and what have you. Example of these are our AFCC, our NAFDAC, our CAC, our SEC, even our courts are in this category. Now, the second category, these are institutions where the government has a controlling interest. Which means even if it is a private institution, as long as the government has a share and interest in that institution is a public institution. A good example of this is our NNTC and our distribution companies, which have been commercialized, but the government still has an interest. And the third and the most controversial so far is our private institutions utilizing government funds. Now, obviously, the private entity would argue and say, no, we are not a public institution. We are a public limited company, a limited liability company. So we do not identify as a public institution. However, the Act has stated that as long as you are utilizing government funds, you are or you identify as a public institution. And courts have interpreted this part of this section in several cases. A good example is the court decision in Obla versus CCEC, where an FOI request was made to CCEC. However, CCEC declined to disclose the information with the defense that they are not a public institution, they are a private entity, and stating that the money received from the government was just consideration and not that they are utilizing government funds. However, the court stated that that money paid to CCEC for the construction of the Katsina-Calabar Road was to do an act that was public, which is for the public interest. Therefore, in that instance, because of by virtue of that contract, that project that they were undertaking for the federal government, they identify as a public institution. There's also the case of EIE project and Coscaris Moto, where Coscaris and climbed the same with the same defense that they are not a public institution. However, the court stated that the money received to get these vehicles for the government means that they identify as a public institution. Thank you.
Thank you, Jemima. Okay, so yes, you've mentioned executive bodies, judicial, legislative, and all of that. And I noticed that the Act is a federal legislation. So I feel like the FOI applies to only federal institutions, that's federal judicial bodies and all of that, right? So state institutions, are they also subject to this FOI Act? Are they going to be under this FOI Act? Can we make requests to them? Can we make an FOI request to state institutions?
Now, Diana, there are two conflicting Court of Appeal decisions on this matter. And the first was delivered in 2018 and the second in 2020. And the first decision was the Court of Appeal decision in Alo Martins versus Ondo State Speaker. Now, the court in interpreting whether or not the FOI applies to both federal and state entities stated that the description of public institutions, public records, under the Evidence Act does not separate federal entities or state entities. It is wholesome, which means it applies to both federal and state entities. The doctrine of covering the field comes into play with respect to the FOI law in those states. However, the Court of Appeal, in the case of overruled its decision in Alo Martins and stated that the court wrongly considered the definition of public records in interpreting whether or not the FOIA applies to both federal and state levels. The court went further to say that the doctrine of covering the field only means that the states that have domesticated the FOI Act the FOIA, or FOI request can only be made to states that have domesticated the FOI Act. So if a state does not have an FOI law, an FOI request cannot be made to the state entities. So it is arguable, but I mean, the court overruled this decision in Alo Martins. So the FOIA applies to just federal entities and states that have domesticated the FOIA. However, it is sad to see that there are still about 16 states that are yet to enact their own FOI laws, and I don't know what the delay is, and I'm hoping that they would, do the right thing soon.
Okay, thank you. We just concluded our national elections in February, I think, and some persons are aggrieved with the decision, with the results. Yeah, some parties, some citizens aggrieved at least. Well, so, and I understand that there is a tribunal that is hearing petitions, right? So now I want to ask for my friend, I'm not asking for my friend. I want to ask, can one make an FOI request to INEC to request for the results? Any information relating to the result, not the results per se, or any information related to the results, yeah.
No, your friend cannot make an FOI request. Well, your friend can make the request. He or she has the right to make the request, but that information will not be disclosed to your friend because that information falls under what we call the exemptions under the Act. Now, I know that the Act gives us the right to request for information from public institutions. However, there are instances where the Act creates instances where the information will not be readily available. It has to be subject to scrutiny of the public interest test to determine whether or not to disclose that information. So yes, that information falls under the exemptions. Sorry to your friend, Diana.
My friend is sad. I'm disappointed. But moving on, yes, you mentioned that it's under an exemption, right? So I'd like to know what are the other exemptions that apply under the Act.
So now we have two exemptions under the Act. We have the unqualified exemptions and the qualified exemptions. Now, the unqualified exemption, this information, they have an inbuilt prejudice test, which means that you do not need to apply the information under this commission carried out on behalf of a public institution. The second information, their information containing course, academic, research, architectural materials conducted by faculty members. And on the third, professional privileges information. Here we have our doctor patients confidentiality, our lawyer clients confidentiality, and our journalist informants confidentiality. Basically, the confidentiality that is conferred by law. Now, the courts have hammered on the fact that this professional confidentiality must be conferred by law. And a good example of this is another of our AIE projects and First Bank of Nigeria, where FOI request was made to First Bank. However, First Bank stated that there was a banker-customer confidentiality. The court stated that banker-customer relationship does not enjoy professional confidentiality. Therefore, it does not fall under this class of exemption. And the second class of exemption is our qualified exemption. This is what we call our injury-based exemption, in the sense that the public interest has to be applied to this class of information to determine the public interest versus the risk in disclosing it. Basically, what it means is, if I disclose this information, if we, the public institution, disclose this information, will it cause more harm than good to the public interest? So if you've determined what it would be, then you decide whether or not to disclose the information. And information under this exemption, we have information concerning international relation of the defense of Nigeria. We have information containing records compiled by public institution in the course of an administrative proceeding. We have professional, commercial, trade secret information. And also, this is where our contracts and bidding processes fall into place. You cannot disclose an information subject to NDA. This is now such as our addresses, our email, and just our personal information. So these are the information that fall under of exemption.
Wow. Thank you so much, Jemima. So yeah, you've mentioned that public institutions, they have an obligation to respond to FOI requests. Again, so I want to know, is it a step they ask, is there a procedure they're supposed to follow? Then when they receive an FOI request, should they say, oh, this is under the exemption, oh, this is not under the exemption? So should there be, what is the state, what procedure to follow when responding to an FOI request, when they get an FOI request?
Okay, we call these procedures the 10 hours. Now, these 10 hours guides a public institution in responding to an FOI request. First hour is register. A public institution has to register an FOI request, which means the date the public institution receives that FOI request must be registered at the front desk. You have to acknowledge receipt from the sender. This is to enable you calculate the days with which it takes you to respond to that FOI request. Mind you, the FOI stipulates that a public institution responds to an FOI request within 7 days of the request. However, in cases where the public institution cannot provide that information within 7 days, the public institution will then write to the applicant, extending the time or informing the applicant that if this information cannot be reasonably available within this number of days, and then extending the time by 7 days. And the second R is to read the information. Now, the FOI officer is expected to read the FOI request to determine what the kind of information being sought, to determine whether or not it falls under the exemption and whether or not to disclose this information. The third R is to record the information. Every public institution is mandated to record every process the FOI request goes through in the public institution. This is because an action can be instituted. So we need this record to guide the public institution. So it is mandatory for every public institution to record the process of the FOI request. The fourth R is to refer the information. Now, in cases where the information is, say, confusing or it's confusing to apply the public interest test, it is wise for the public institution to consult senior executives or other public institutions to determine whether or not to disclose the information. The Act also stipulates that where it is difficult to apply the public interest test, the person is to reach out to the Attorney General to apply this public interest test to determine whether or not the information should be disclosed. And the fifth R is responsibility. This is where you have to reach out to the different departments where this information can be retrieved from. Now, mind you, all this has to be done within the time frame of 7 days or the extended 7 extra days. So you have to reach out to the different departments and source for this information. And the sixth R is the retrieve, which is basically retrieving the information from every department and compiling it. Now, the seventh R is to redact and disclose. Now, there are some cases where some information, when an FOI request is made, some information can be disclosed and others cannot be disclosed. In cases like this, the public institution is encouraged to redact, which is like conceal the parts that cannot be disclosed, and then go ahead to disclose the parts that can be disclosed. Now, the eighth R is to review the information. Once the information is compiled like that, the public institution is to, the top executives in the public institution is then to review this response, the FOI response, and ascertain that this is truly answers the questions that the applicant has asked. So every FOI request must be reviewed before it is then sent out. Now, the ninth R is to respond. It is very important to respond within 7 days. So the public institution, after reviewing, passing through all the processes and then reviewing and determining that okay, these are the information that are available. The public institution then responds to the FOI request, attaching relevant documents, CDs, like I said, pictures, photographs, what have you, attaching the relevant documents and record, and then responding to that FOI request within the time limits. The last R is to release the information. Anytime an FOI request is made to a public institution, the public institution has to, after responding to that applicant, now release it in their public scheme. This could be their email, their website, sorry, or their public brochures or whatever they use, to pass information. They have to release that information. That information now has to be readily available to the public. So someone does not have to come back and request that information. It is there, So that is the step to follow. Those are the 10 R's that an NTA has to follow in responding to an FOI request. But it's very important to note that if a public institution does not intend to respond, does not intend to disclose what is called a notice of refusal. Now, in your notice of refusal, you are telling the applicant, we cannot disclose this information because this. You have to state your reasons for refusing to disclose the information. You cannot just stay and say, okay, this information cannot be disclosed, so we will ignore this applicant. No, you have to respond via a notice. If a public institution fails to issue a notice of refusal, the applicant can, after 10 days of that wrongful refusal, it is called a wrongful refusal, a public institution refusing to respond to an applicant. After 30 days of that wrongful refusal, the applicant can then institute an action, go to the courts to mandate the public institution to disclose that information. Where the court finds the public wrongfully refuse to disclose the information, the public institution will be liable to a fine of 500,000 naira.
500,000 naira.
Thank you, Diana.
Thank you, Jemima. So my next question was going to be, remedies available where an MDA, that's a Ministry Department agency, where an MDA does not, respond to an FOI request, or you've explained that one can, institute an action against the. Quickly, now, Alan, we understand that the Act, right? The Act mandates public institutions to, respond to FOI requests and all of that. And then Jemima has also mentioned that there has to be some scrutiny, decide if this information it's supposed to be exempted or not, right? So is there a process to, scrutinizing if this information is supposed to be disclosed or not? Is there any,
Yes, all right. So thank you for that question. There are exemptions to disclosure. Remember, the Freedom of Information Act guarantees the disclosure of public information by public institutions. Okay, it enhances open governance, transparency, and accountability in governance. But you will agree with me that every information should not be disclosed. So there are exceptions to freedom of information. And the exceptions are broadly classified into qualified exemptions and unqualified exemptions. So qualified exemptions are the ones that are conditional. Unqualified exemptions are the ones that are absolute. So whenever an absolute exemption or an unqualified exemption is engaged, you do not disclose. The answer is don't disclose. But whenever a qualified or a conditional exemption is engaged, you conduct something known as the public interest test, right? You conduct a public interest test. Now, keeping in mind the fact that if you refuse to disclose information under an FOI request, it has liabilities, potential liabilities. Now, a public interest test has to be very thorough to ensure that your basis for a disclosure or a refusal is valid. All right, so we'll try and walk through a PIT test we would have a simulated PIT test so that we can, understand how it's done. So a PIT is written like a legal opinion, all right? You start with the facts, okay, or a summary of the FOI request. That's the first paragraph. You do a summary of the FOI request. Then in the second paragraph, you consider the advantages of a disclosure. What are the advantages of a disclosure? Then in paragraph 3, you consider the disadvantages of a disclosure. It's also known as the injury that may be suffered by a disclosure. That's paragraph 3. You consider the disadvantages of a disclosure. Now, in paragraph 4, you do an evaluation, okay? Which one outweighs the other? Are the advantages stronger than the disadvantages, or is it the other way? Now, the ground rule is if the advantages outweigh the disadvantages, you disclose. If the disadvantages outweigh the advantages, you do not disclose. And if the advantages and the disadvantages are evenly balanced, that means they cancel out each other, then the FOI officer has a discretion to disclose or not to disclose. That's the ground rule. So when you get to evaluation, I think it's paragraph 4 now. When you get to evaluation, you have to weigh whether the advantages outweigh disadvantages, and based on your evaluation, paragraph 5 will not be your advice. So let's say that an information or an FOI request is requesting 5 details, and 3 can be disclosed, but 2 are confidential in the sense that they impact on people's personal data, people's account details, people's residential address. In your paragraph 5, when you are recommending, you may recommend a part disclosure and a part reduction. So you can say disclose numbers 1 to 3, but do not disclose numbers 4 and 5. You can recommend that in your PIT opinion, okay? Then paragraph 6, which is the conclusion of a PIT opinion, is going to remind the person making the request that they have a right to go to court to seek judicial review. They have a right to also write the head of that parastatal to seek a review. So that's the anatomy of a public interest test opinion. Now we are going to use a simulated scenario, and I think we would attempt to draft one. So let's say I am the FOI officer in the national asset. Okay, I'm the FOI officer in CBN, all right? And somebody sends an FOI request saying, provide us with the capacity building budget. Tell us how much was spent on training of CBN staff members in the year 2022. I received that kind of FOI request. And it comes to my table for me to make a public interest test opinion. What I will do is I'll start with paragraph 1, where I will state the summary of the FOI request I received, which is a request to disclose the training budget for CBN staff members and how it was spent. That is paragraph 1, the summary. Then in paragraph 2, I'm going to talk about the advantages of a disclosure. Here, I will say that there is a need for accountability. There is a need for transparency in governance, which includes how government money is spent. So disclosing this is going to advance transparency and accountability. Now, in paragraph 3, I'm going to talk about the disadvantages. All right. If we publish if we publish how much each CBN staff member received by reason of training, it might put them in harm's way. You don't know how they live, you don't know where they live, you don't know, it just impacts their privacy, and it puts their financial and personal data out there. So that is a disadvantage of disclosing this information. Then in paragraph 4, when I'm doing my evaluation, I can say that the advantages outweigh the disadvantages. In other words, there is a need, there's an overarching need for government transparency and accountability as concerns the needs of an individual privacy. So, but I can now put an observation, but there is a need to redact the names and account numbers of those individuals, but we have to know the total amount that was spent for the training. Then in my paragraph 5, I'm then going to say, disclose the budget, give a breakdown of how it was spent, but redact the names and the account numbers of the CBN staff members that are beneficiaries. Then in my paragraph 6, I'll state you have a right to approach the court for redress and all of that. Now, where the issue lies is in the evaluation. FOI is a very delicate and I think is largely a margin area. So that skill to make evaluations is one that requires training, and that is part of what we do, in our S&A Academy. Not to do some marketing, but then that's what we do, and we do a good job there. So the fulcrum of a PIT opinion rests in that evaluation, and it requires a lot of training and expertise. I believe this is the summary of how to determine whether to disclose information or not under the qualified exemption. Thank you.
Wow, thank you, Alan. Sounds like a lot, and I agree with you. Staff of public institutions need to be trained, to be able to conduct this PIT test. And it's not just public institutions, as we know, even institutions, that's private entities that utilize government funds, such as construction companies that have funds to construct roads. They will need to, if I make an FI request to them, there needs to be a staff that would, respond to my FI request. Thank you, Alan. And you've also mentioned that the S&A Academy is competent to, handle training such as this. Okay, so quickly, what we've been saying, on the fact that citizens have right to request for information from public institutions or government officials. Now, there's an Official Secrets Act that provides for the protection of official information. And I also know that there is a section of the criminal code that prohibits the disclosure of official secrets. Does this not run contrary to all we've been saying, that we have access to information they're supposed to disclose and all of that? So will government officials be able to rely on the Official Secrets Act and criminal code to, refuse to respond to an FOI request?
All right, thank you. So the answer is the FOI Act overrides the Criminal Code and all the Official Secrets Acts. It overrides it. It has a superior application and effect. So let's just give a vivid example how it works, right? I'm talking about sections 1 and 2 of the FOI Act. Now there's a provision in the FOI Act that's called the whistleblowers provision. So if, for instance, I'm working in maybe Ministry of Aviation or Nigerian Civil Aviation authorities, all right, and I receive an FOI request regarding the Nigerian Air, right? So if I receive that request, there is no invocation of Official Secrets Act or Criminal Code or anything that will stop me from disclosing the information requested pursuant to that FOI application. I will disclose it, right? But then I will not, of my own volition, without an FOI request, disclose such information, because it will smack of bad faith. But I will just wait for the FOI request to come, pursuant to which I will disclose, and no superior orders or anything will stop me from disclosing that. So to answer the question, OSA Criminal Code will not override the FOI Act, and it's expressly stated so in the FOI Act.
Thank you, Alan.
Thank you.
Yes, so in the course of our webinar, we've received questions, and I believe we can address them here and now. So my first question here is, Alan, to you.
Okay.
Can a public institution make an FOI request to another public institution?
Okay. A public institution will not typically make an FOI request to another one because of something called interoperability of governance and government. So government is seen as a continuum, as it's seen to be interoperable. So let's say the FIRS wants an information from the CAC. They won't make an FOI request. They'll just make an intergovernment notification or circular, or they can even set up a JTB, okay, a joint tax board or anything. So governments communicate within themselves, especially at levels. Federal government institutions, communicate within themselves, and same thing with state government institutions. But there are instances where an investigation may happen or something may happen. Let's say during the e-Naira issue, when the Ministry of Finance said that the CBN was not carrying them along. Whenever there is that intergovernance or intergovernmental friction, then an FOI request can actually be made saying, give us this information. So yes, it's not typically made, but yes, it can be made in, under the kind of scenario that I've painted, yes.
Okay, thank you so much. Secondly, the second question for you, Alan. Okay, so it says, this one's funny, What if I make an FOI request to a public institution and the institution informs me that it lost the information or it has been swallowed by snakes or monkey? What then is the remedy?
Let me even add to that, or it has been eaten by termites, yeah? All right, so the thing is, public institutions are mandated to keep records. We're going to come to, maybe another webinar is going to address records keeping, but then every public institution has to keep records that are within its custody. And it's not an excuse that such records, in fact, it is even a violation of the FOI Act to say that such records are missing. Records have to be kept. Whenever letters and documents are received, the register of the receipts and the transfer of such documents also need to be kept. So it's a violation of the FOI Act to say that termites ate the voucher, or maybe that a mystery monkey carted away with the public funds and all of that, or anything of the kind, So yes, that's the answer. It's a violation. It's not an exception or an excuse under the FOI Act. Yes.
Okay. Thank you, Alan. So Jemima.
All right.
There's a question for you.
Okay.
Someone wants to know, what you say is is there a lack?
Okay, yes. First of all, I would like to say that the FOI Act is a welcome development. I mean, it took us 12 years. It took 12 years for that law to be enacted. So big ups to former President Jonathan for passing the act into law. However, I feel like the act can be improved in a lot of ways. For me, I believe that there are too many exemptions in the act. That is, there are too many restrictions on the disclosure of information. I mean, the act only provides for, section 1 and section 3 are the only easily disclosable information upon request. Then we have about 10 sections, 7, 11, 12, 14, 16, 10 sections, which cannot be readily disclosed. I mean, this feels like it is easy for public institutions to feel like they have a loophole, a means to hide under, to refuse to disclose an information. I mean, if you see most of our FOI cases, you have public institutions stating that all this information falls under this exemption or that exemption. And then the courts now has to come and then interpret and say, no, disclose it. So I feel like there are too many exemptions. So I beg our legislators to look into that. It could be better. And then there's also the obvious fact that there's illiteracy in Nigeria. The rates of illiteracy in Nigeria is really high. I mean, not a lot of people know about the Freedom of Information Act. And this act was enacted for the people in order for us to hold the government accountable, to foster transparency in the government. If we don't know about this act, how can we then implement it? How can we then use it as a tool to hold public institutions, hold the government accountable for their actions? There should be a way, of making this act known to the public. So these are my these are the lacunas I noticed in the FOIA. And I believe that we can work on it. I believe that it's something that can be, can be fixed. Thank you, Diana. Sorry, Alan, we can't hear you. Alan, we can't hear you.
Muted. I'm muted. Apologies. And I've been talking, right? Okay, so we have two questions here, anonymous questions. The first question is, can I make an FOI request with regard to military operations in Nigeria vis-a-vis their rules of engagement and compliance with international best practices? All right, so yes, it will depend. Let me give a scenario. If your FOI request is to the Nigerian military saying, give us all the information regarding your Boko Haram, operations, the answer is no, you cannot get that information, okay? Because under Section 11 of the FOI Act, it is a valid, one of the grounds for withholding information is information that will compromise the defense of Nigeria, and under that Section 11, the Nigerian Army can actually decline your FOI request, and for very, very good reasons, But then, if your FOI request, is requesting to know how the budget, how the $1.5 billion that a former president of Nigeria applied for to fight Boko Haram. Okay, if you want to know how those resources were used, you don't want to know the intelligence plan and all of that, but you just want to know how it was used, then yes, your FOI request will have valid grounds. You have to know how many Tucano jets, fighter jets that they bought with the money, how many tanks they bought with the money. You are entitled to know that, but you're entitled to know where they deployed the tanks and all of that. So that's it. Section 11 answers that question. It is a qualified exemption, and a PIT will determine the outcome. Then the next is, can I really depend on the FOI information put out there for public consumption, right? So I understand that trust for governments is considerably low this time, considering the fact that oftentimes when government comes out to deny something, just give it like a week or two. Oftentimes, in very few occasions, it turns out to be that that thing that was rumored turns out to be the reality. I understand that the trust is low, but we don't have a choice. If the information is within the custody of the public institution giving it, you have to just rely on what they give to you. You cannot manufacture yours, because it's not an information that ordinarily lies within your custody, and we can't even produce it because it's not in proper custody. So yes, you have to rely on the information that they give you when you request or when you make an FOI request. Then if you think that is not adding up, you can interrogate the government agency concerned. You can take the conversation further. There are, I guess that's those are the two unanswered questions right now. So thank you everyone for making our time. Please, if you have any questions, you can just put your hand up. Okay, a third question. Can I make an FOI request to an NGO, for example, a charity organization that solicits funds from the public to carry out its object? All right, we're going to come to this. When we say public interest, we don't mean soliciting funds from the public. Like there's a difference. Public interest does not mean interesting to the public. So something can be interesting to the public, but it will not be of public interest. So public interest has to be something that advances accountability, transparency, and open governance. So if somebody is soliciting funds from the public, that is from you, from you and I, all right, it is not really of public interest. Okay, it might be interesting to the public. Oh wow, these guys are scammers. They are NGOs. They keep fleecing people of monies and they don't use it. It can be anything else than public interest. It's when it comes to governance, our taxpayers' money. How is it used? That is public interest. So I just needed to make that clarification. I don't think you can make an FOI request to an NGO because it will not qualify as a public institution except it is using taxpayers' money. Then it will be subject to an FOI request. All right. So okay, yes. So Diana, over to you. Over to you.
Yes. Thank you so much, Alan. Thank you, Jemima. Okay, so I understand that there may still be more questions. You know, if you have more questions and you are unable to send right now, you can send to our email. Like I said earlier, our email is info@sholoraapana.com. Okay, so thank you everyone for attending. You know, our time is fast spent and everything that has a beginning must have an end. So we have to say our goodbyes. I know that goodbyes are the hardest things to say. So again, thank you, Alan. Thank you, Jemima. Thank you everyone for taking our time to attend our webinar. And we are here for you to answer your questions. You can just send, like I said, send your questions to. All right. So thank you.
All right. Thank you. Thank you everyone for having us. See you some other time. Okay.
Yes, some other time. Watch out for our next webinar series.
All right. Bye.